It's 0002032. Ngabama Beke on SAFM.
Indeed, the Legal Sector Code Steering Committee welcomes the gazetting of the code by the Minister of Trade and Industry and Competition in terms of Section 9.1 of the Broad-Based Black Economic Empowerment Act, which will transform the legal profession and address the imbalances of the past. This is a historic milestone in the transformation of the legal sector. There are structural challenges faced by black practitioners, especially women, as a result of historical inequalities. There is inadequate access to a sustainable flow of quality work from the private sector, discrimination by the private sector in terms of procurement and specialized work, inconsistent briefing patterns from organ of states and SOEs, unequal access to senior positions in radically mixed law firms, in particular in your large LSMEs, and a lack of skills resulting from limited access to quality and specialized areas of work. There's so many issues associated with that, so let's have a conversation with one who's got the experience and who's certainly in the attorney's profession experienced all of these issues and has nonetheless been able to blaze a trail in her chosen vocation. And such a great honor to welcome Umama Christine Qunta. Mama Qunta, good evening. Thank you so much for joining us. I'll brag just before you get onto the show. The first time we met was at the launch of the Thabo Mbeki Foundation. This is October 2010, and it was because of your ticket that you sponsored me that I was able to get in there. So thank you very much there. I met President Mbeki, John Kufuor, former president of Ghana, the same thing with President Joaquim Chissano, all the who's who in the Thabo Mbeki world. So again, I thought I should remind you that in continuing to recall what a pleasant honor I had. Thanks to your benevolence, Mount Qunta. Good evening.
Yes, good evening, Maba, and good evening to your listeners. I don't actually remember because I'm always doing that, but yes, I'm glad I could be of assistance.
Well, I certainly do not forget, and thank you so much for that. Let's talk about the legal profession. This is something which has long been in the offing. Of course, it's not a new conversation in the context of ultimately working towards transforming the legal profession. And some of the issues that are highlighted are as old as the legal profession, particularly in the democratic dispensation where you see it in any area of the law, be it you go to your top law firms, be it you get the high-profile cases that require seasoned senior counsel. The pattern is always the same, largely white male, but largely white, very few women, if any, on those matters. And the reality is, of the professions that ought to really have taken charge of the transformation project, the legal community has been very slow. In fact, it's probably one of the worst performing. And you see it in terms of how it plays out, where critical persons and positions are required. It's oftentimes the same faces. How does this proposal, at least the legal sector code, now that it has been gazetted, propose to change that, which will be new especially?
Thank you. Yes, I think it's important to explain to listeners who may not know much about Black economic empowerment, and in particular the Act, the Broad-Based Black Economic Empowerment Act. So since 2007, there has been the generic codes which contain scorecards that are applicable generally to all companies. But those scorecards are not applicable to specific sectors. So the Act also allows the Minister of DTIC to gazette sector-specific codes. And that has happened over a period. We've got the construction sector code, we've got the property sector code, the financial sector code, and now the legal sector code. The legal sector has attempted twice before to have some kind of charter, but neither of those initiatives succeeded. I'm not quite sure why. So the law firms that choose to be measured in terms of Black economic empowerment, or BEE, they have used the generic scorecard. And the problem with the generic scorecard, it is not suited to a sector, a services sector like the legal sector, and therefore it would be easy to get scores and points because it's not sector specific. That's the first problem. The second problem is that there is no monitoring mechanism built in to the generic scorecard. Now, since the establishment of the BEE Commission, companies are required to file reports, but that's not an actual monitoring mechanism. So what the legal sector code that was gazetted on the 20th of September does, it provides sector-specific intervention because the steering committee and practitioners who contributed to the development understand how the legal sector works. For example, as you would know, you cannot be a director of a law firm if you are not an admitted attorney. And therefore, only admitted attorneys can be directors. And then you have salary directors and you have equity directors. The equity directors are really the people who participate in the profit of the firm and, of course, the liability too. So what we have done with and when I say we, I mean the steering committee and the practitioners who contributed greatly to the improvement of the code, is that we've said, for example, in large firms, which is firms that make the turnover is above 25 million, only equity directors are counted in the management control scorecard, so that we are enabling Black directors to actually have power within those firms instead of just being salary directors. So those are the examples of how the legal sector code will be more effective than the generic scorecard. Plus, we'll have a charter council that the Minister of Justice will set up, and that charter council will monitor progress because law firms who are bound by the sector code will have to file annual reports on how they can progress. And the code provides for a 5-year progression. That's the other thing with the generic scorecard. It just said 25% of directors or management control is required, and that remained, the ownership target remained at 25% for since 2007. I mean, that's almost 25 years. So that's the difference between the generic scorecard and the legal sector code.
Qunta, thank you for that. And it does sound to be progressive. It is novel, and certainly it creates for an environment where compliance is possible. I'm not so sure if it creates for an environment where compliance is incentivized. And perhaps that's always going to be the challenge, that you might have these regulatory instruments at play, perhaps. But one, it doesn't sound like, and perhaps I might have misunderstood you, and please engage me to the extent that I have misunderstood you, that to what extent is compliance required, and where there is no compliance, there are punitive measures that will be taken? Because I think the culture of compliance in terms of these targets, it reflects in the slow pace of transformation. And I don't imagine this one, simply because it's now addressed to the legal community, is going to follow a pattern that is dramatically different to how we have seen transformation generally in our society, particularly in commerce, play itself out. So perhaps from a position of what the law says, because anything that is gazetted ultimately is law, to it being complied with, and to the extent that it isn't complied with, what then becomes of the punitive measures, if anything? Or put differently, if punitive is not necessarily the term to engage here, what are the incentives for compliance? Just that on for now, please.
Yes. The incentives are the usual in terms of generic scorecard. You get points, and that's the number of your compliance with the 5 scorecards, in this case 4 scorecards, because it doesn't include socio-economic development, because there's a separate piece of legislation for pro bono work. But the extent to which you comply with the 4 scorecards, that is ownership, management control, enterprise and supplier development, will determine what the level is, your BE level certificates, whether it's level 1, 2, 3, 4, 5. And when you tender for government work, whether or not you get the tender and how competitive you are, apart from the issues of price, will determine the level. So that's the incentive which is prescribed in the B-BBEE Act and which the legal sector code mirrors. Now, there's no punishment per se, except that you are unlikely to do well. You are unlikely to do well if you don't have a good BE compliance, and you have to be measured now in terms of this code. And as I say, the code contains very detailed sector-specific interventions. I also want to, maybe I need to explain who has to comply with the code.
Yeah, please.
Not everyone, not all law firms or advocates, and that's the other unique thing. Advocates will also be measured. But if you, for example, your annual turnover is less than 5 million, if you're a law firm, you're not obliged, whether you're black or white, you're not obliged to comply with the sector code. Unless you yourself want to get a good scorecard or a certificate, then you can. Advocates, if your annual turnover is less than 3 million, you don't have to comply. And whether you're white or black, and you get an automatic level. You also don't need to spend money to get verification. All you have to do is to do an affidavit which says what is your percentage of black ownership and what your annual, or confirm that your annual turnover is below the threshold. Now, anyone above 5 million, law firms, advocates above 3 million, you elect. So the choice is with law firms. They don't have to comply and they don't have to be measured in terms of BE. It's only those who choose. The only problem that they will have is then it means they cannot do business with government. Because if they do business with government will require them to produce a BE certificate. And so for that reason, it will probably sort of incentivize them to be measured. And if they choose to do so, it's the legal sector code that they will use.
We'll talk about the role of government in ensuring then that these incentives really are carried out and that everybody who qualifies for obviously the compliance open close code is sufficiently incentivized, and that this is a mechanism that is actually monitored. It's one thing to have compliance that is required by operation of law, and quite another for that to be monitored and evaluated and there to be repercussions either way in the context of whether or not the compliance has been met. Let's take a break. Mama Christine Qunta, the chairperson of the Legal Sector Code Steering Committee, is on the line. We're talking about latest developments in ensuring there is transformation in the legal fraternity following the gazetting of the code by the Minister of Trade and Industry and Competition in terms of Section 9.1 of the B-BBEE Act. The time is 20:30. After this very short ad break, we continue the conversation, and Mama Qunta, I'm going to focus on the role of government and government agencies have in ensuring that this transformation actually means something for those who are in the legal field. After the break, we do continue.
Do great solutions start with good conversation?